Welcome to this, the third video in my series on the basics of the music business. In this video, we're going to focus on copyright societies, who they are and what they do. Any composer, whether you have a publisher or not, should consider membership with your local society, and in this video, I hope, I will explain why. So let's get started. Performing royalties are payments made to the copyright owner, i.e. not the artist but the composer and or publisher, and they are based on fees paid by music users and broadcasters. We'll look at performance royalties later. The rates are set by the local copyright society and collected by them on behalf of the copyright owners. Music users such as broadcasters, radio and television, etc., pay licence fees on an annual basis to their local copyright society and declare the use of each individual work either on a monthly or weekly basis. The Copyright Society analyses the data it receives and makes payments to the copyright owners accordingly, and in the UK, this would be handled by PRS, the Performing Rights Society. Mechanical royalties are payments to the copyright owner based on fees collected by pressing plants. The rates are set by the local Copyright Society under guidance from the Beam Standard contract and administered on behalf of the copyright owners. Music duplicators, such as pressing plants, charge a fee on behalf of the Copyright Society for every duplication of a musical work. In general, this applies to physical copies of a musical work, but can also apply to digital copies. Streaming services such as Spotify, Beats, Pandora, etc. also pay a virtual mechanical royalty in the form of a hybrid total payment based on a performance royalty and a sale as a combined fee. In the UK, this is handled by MCPS, the Mechanical Copyright Protection Society. Performance royalties are payments made to the performers based on fees collected by the neighbouring rights organisations. In the UK, this would be PPL, the Phonographic Performance Limited, which was established in 1934 to ensure that performers are paid for the work that they do by licensing the rights to broadcast recorded music. VPL, which is the Video Performance Limited, is the sister organisation of PPL working specifically in the area of music video broadcasts. If you make music, even if you're signed to a label, you should be a member. It is also important to remember that PPL and VPL is not only for the lead artist. If you contribute to a musical performance of a work, you should be a member. Neighbouring rights are very separate and distinct from mechanical and performing rights. Neighbouring rights are not related to your ownership of your intellectual property. So let's take a look at a simple diagram to explain it all in a bit more detail. As a composer, you've written a song, and that song is performed live. PRS collects payments and pays it to you. The recording of the song is duplicated. MCPS collects the fee and pays it to you. When it's broadcast on the radio, PRS collects the fee. PPL and VPL collect fees for broadcast performances and pay them to the performer. Copyright conventions. The Berne Convention for the Protection of Literary and Artistic Works was spearheaded mainly in 1886 by Victor Hugo, who was a member of the French society representing authors' rights, the Association littéraire et artistique internationale. The convention embodies the French concept of the right of the author, le droit d'auteur, more commonly known as the moral right, and it forms part of a more economically orientated concept of copyright. In other words, the moral right of the author relates to the personal ownership of a creative work, whereas copyright relates to the exploitation of that creative work. It is worth noting here that the modern concept of copyright existed in England as far back as the beginning of the 18th century with the Statute of Anne in 1710, where copyright could be applied for a period of 14 years with an option to renew for a further 14 years. Therefore, under the convention, the moral right on a creative work is automatically in force upon its creation, specifically when it is embodied in a physical form, written down or recorded, without the need to assert or declare the right of authorship in countries who have signed into the convention. At the point that the work is fixed, i.e. written or recorded on some physical medium such as a manuscript or a CD, its author is automatically entitled to all copyrights in the work and to any derivative works, unless or until the author explicitly disclaims them, or until copyright expires. Copyright expires generally between 50 and 70 years after the death of the creator, depending on the territory. In the UK, it's 70 years, although there are some exceptions in the case of film scores and anonymous works, and artistic works, photographs, etc., and in the case of computer-generated works which only have a 50-year copyright life. Foreign authors are given the same rights and privileges to copyrighted material as domestic authors in any country that has signed the convention. The UK was one of the original signatories in 1886. This superseded the 1710 Statute of Anne. The World Intellectual Property Organization, based in Geneva, Switzerland, was established in 1967 to encourage creative activity and to promote the protection of intellectual property throughout the world. In the French-speaking world, it's known as OMPI, the Organisation Mondiale de la Propriété Intellectuelle. WIPO took over the role of the Bureau International Réuni pour la Protection de la Propriété Intellectuelle, which was created in 1893 to administer the Berne Convention. WIPO has 187 member states, including the Vatican City, and it also allows Palestine to have observer status. WIPO is also one of the specialised agencies that advises the United Nations, and has a mandate to focus their attention on the implications of technology on intellectual property rights. The WIPO Copyright Treaty was adopted in Geneva on the 20th of December 1996 with the intention of developing and maintaining effective and uniform rights for the authors of creative works, introducing new international rules and clarifying current interpretations of existing rules in line with new economic, social, cultural and technological developments, emphasising the significance of copyright protection as an incentive for the continued creation of artistic works, and recognising the need to maintain balance between the rights of authors and the larger public interest, specifically in the fields of education and research. BEAM is the organisation responsible for international mechanical copyright control and was established in 1929 for Europe and extended internationally in 1968 as the global representative organisation for all mechanical copyright societies. The MCPS in the UK is a BEAM member. BEAM sets standards and fees for mechanical copyright. The current recommended rate is 8.172% of the PPD, published or purchase price to dealer, but this is open to variation by individual mechanical copyright societies and used to set standard fees for blank cassettes and other recording media, but this has now been devolved to governments of each individual territory. BEAM are also responsible for monitoring EAN, the European Article Number codes. That's the barcode on your CD or DVD, etc. Copyright law. Registering a work with the Copyright Society does not create copyright. It is simply a registration of your claim to copyright under the terms of both Berne and WIPO. In other words, what you register with your Copyright Society is your claim to moral right. The 1886 Berne Convention and the WIPO Copyright Treaty of 1996 established the right of a creator to be identified as such and to claim copyright on the works he or she creates, the moral right. In other words, as soon as a musical work is either recorded or written down, sheet music for example, it is protected by international copyright law. However, it is still the responsibility of the creator to prove this right in respect of his or her works. You can do this in several ways. You can send a copy of your recording to yourself, register delivery, and do not open it. This establishes a date stamp. Store a copy with your solicitor or a bank, but that may be expensive. The date stamp on your DAW file may be accepted as proof of ownership at a specific date and time, but it has yet to be proven in courts throughout the world. Every country has a specific law, compliant with the WCT of 1996, enacted to protect the intellectual property rights of its citizens. In the UK, this is the Copyright Design and Patents Act of 1988, which was updated and amended in 1996 and further. Under such law, an organisation can be set up to ensure that the articles of this law are maintained, and that any income generated is properly distributed. In the UK, this is PRS MCPS. Globally, the Copyright Designs and Patents Act of 1988, along with all of the other similar laws in all of the other WCT signatory countries, form the international composer's rights, giving the composer, the right to duplicate the work, the right to issue, sell, lend or rent such duplications to the public, the right to perform, show or play the work in public, and the right to communicate the work to the public, i.e. via broadcast, radio, television or internet, etc. Copyright societies. So what does a copyright society actually do? Well, they administer your royalty income, they provide legal protection for your intellectual property, and they work behind the scenes with their sister organisations to ensure global agreement and smooth transactions. Under the Berne Convention, all individual territories' copyright laws must comply to the global articles set out in that convention. In other words, whether you're a PRS MCPS member, or a member of SACEM in France, GEMA in Germany, Buma-Stemra in the Netherlands, or any other recognised copyright society, the royalties and payment systems are more or less identical. There are some local variations to watch out for, though. The copyright society of the country in which you and your works are registered will be the society who pays you, irrespective of the territory in which your works are used or broadcast. All uses of your works outside of that territory will be reported to and accounted to your local copyright society. You don't get paid by every single copyright society separately. If you are an EU citizen, current regulations state that you may join any copyright society from any member state, but this may change. In the following example, we will assume that you're a member of the Dutch Copyright Society, Buma-Stemra, where Buma handles performing royalties and Stemra handles the mechanical royalties. So, if you're a Buma-Stemra member and your 4-minute-long single is broadcast in the Netherlands on their national FM station 3FM, this is what you would be paid. Remember, there's a local variation here that Buma-Stemra regulations state that a music publisher cannot claim more than 1/3 of a composer's royalty share, although this is 1/2, 50%, in the case of instrumental music. SENA is the local neighbouring rights organisation and they would pay the performers. And if you're a Buma-Stemra member and your 10-track CD album is pressed in the Netherlands, it'll go to the pressing plant. These are the fees that will be charged and this is what would be paid to you. And finally, if you're a Buma-Stemra member and your music gets radio airplay, for example, outside of the Netherlands, in the UK maybe, or even in the US. This is the path that the payments would follow, and this is how it would end up with you. Royalty payments will be collected by the society local to the broadcaster and passed on by that society to your own copyright society, who will then pay you. Foreign societies may deduct fees when making inter-society payments. So what does a copyright society not do? Well, they do not publish your work. They do not actively seek out revenue, and they do not promote your individual works. When you join a copyright organisation, you sign a contract. You are effectively assigning your rights to the society so that they can legally represent them, if necessary, and giving them a mandate allowing them to act on your behalf and administer any revenue related to the works assigned to them. It is not a publishing contract. This assignment does not affect your right to assign a publisher to promote and generate revenue from your copyright. In other words, a copyright society is more concerned with defending your moral rights and administering your income, while a publisher is more concerned with the exploitation of your actual copyright and generating an income. Registering your works. If you're an unpublished composer, you can register, update and amend your works yourself. If you have a publisher, he or she is obliged to make these registrations for you. In order to make a registration, you will need at least the following information: the title of the work and any alternative titles, the full chain of ownership, i.e. each composer and publisher and their society membership numbers, the duration of the work in minutes and seconds, and any known usage to date. Any known intended use, library music, commercial music, etc. should also be noted. This example here is a PRS registration form, and as you can see, it's fairly clear and straightforward and covers all of the items that I've just mentioned. Once your work is registered, you will then get a chain of ownership form, and as you can see here, it details everything about that composition. And so, to finish off this lesson, as always, here are some useful links. So, as you can see, much of your income as a composer will come from your PRO. If you're not a member, then quite simply, you won't earn any royalties. In the next video, we will look at the basics of music publishing. But in the meantime, again, please like and subscribe for more content like this. And you can also support us, as always, on patreon.com/Lavender Vale. Thanks for listening, and see you next time.